Let's take a look at the judicial branch of the United States. Judicial review is the right of the Supreme Court and the federal courts to declare acts of the executive branch and laws passed by Congress to be unconstitutional. John Marshall was the second Supreme Court Chief Justice, but he was the most important. There's a huge bronze statue of John Marshall near the courtroom in the Supreme Court building. When looking at judicial review, there are two sides: the strict constructionists that look at what did the framers intend, and there are those who are known as activists who feel that the courts should find a way by which to, if necessary, change law for changing conditions. And they should be looking at not necessarily the intent of the framers, but what is best for the nation. Development of federal courts has happened in three distinct periods in the country's history. There's the first period from 1789 to 1865 was national supremacy and slavery were the issues. Marbury versus Madison in 1803 set up the fact that the federal courts had the right of judicial review. In all these cases, you can look at the details in your text, but in the Marbury case is the most important case. In that case, Justice Marshall took for itself something that isn't written in the Constitution, but the right of the courts to review acts of the president, review laws passed by Congress, whether or not they're in the bounds of the Constitution. In 1819, there was a case that involved whether or not the federal government had a right, or excuse me, a state government had a right to tax a national bank. The Marshall Court said no, but with it, as I've explained in another PowerPoint and you've read, it set up the American ladder effect of American law, whereby the United States Constitution is supreme and state constitutions and state laws are subordinate. Dred Scott versus Sanford in 1857 has to be looked upon as being a cause of the Civil War. In that case, the Supreme Court under Chief Justice Taney decided that slaves could not be freed, that they had to be returned to their masters because the federal government had no right to get involved in state laws that allowed slavery, which of course by 3 years later were fighting a war. And in this period, more and more so, interstate commerce was controlled by the federal government, commerce between the states. Second period, 1865 to 1937, after the Civil War, the question became the government and the economy. Can the economy be regulated by the feds and state governments? What are objects of private property in the contract clause? Was it reasonable regulation for the federal government to coin money, to decide the value of money for the banks of the United States? All that became moot during the Great Depression. With the Great Depression, the federal government, with the Securities and Exchange Commission, with the Social Security Commission, with taking the nation off the gold standard, all that ended with the court deciding that yes, the federal government had a right to control the economy. Third period from 1937 to present has been looked at as protecting civil liberties. Symbolic speech and speech itself, whether or not in the Schenck versus U.S. case in 1917, if speech can be seen to be an imminent danger to what the government has a right to protect us from, then you don't have that speech. This is one of the first cases whereby there was not an absolute freedom of speech, press, religion, petition, assembly, and so forth. Also during this time, they looked at the separation of church and state. In more and more so, the government had to show a reasonable point to get involved in religion, and more the court said no, that the state cannot get involved in religion. Matt versus Ohio in 1961 set by the exclusionary rule, whereby evidence obtained as a result of an illegal search cannot be used in a court of law. The Miranda case in 1968 took the point of police procedure whereby police must inform you of your right to remain silent. Roe v. Wade in 1972 decided that in the Ninth Amendment, women had an absolute right to privacy in their own body, and therefore in the Roe case, abortion was seen that the states could not abolish abortion, and that a woman had an absolute right to an abortion if she wished to have one in the United States. The Furman case in 1972 set the stage that in this case the death penalty was found at the time to be unconstitutional because it was found to be racist, that there were more minorities that were put on death row, and the way in which the states were administering the death penalty afterwards, the states had to find a way to show that they weren't being arbitrary and capricious. But as a result, you have less than 17 states today that still have the death penalty. Looking at this chart, laws overturned by the Supreme Court in the 20th century, you can see that the court has not been very active with the black line and the regulation of the economy. That ended with the Great Depression. You had more and more cases spike in the 1950s through the 1970s in regulation of civil liberties, but those have gone down, and you've had those great periods in regards to the economy and the civil liberties. Structure of the federal courts. Supreme Court on top. You have 12 U.S. Courts of Appeals for the Federal Circuit, Court of Military Appeals. You have state Supreme Courts. How can you manage to get a case to the Supreme Court? Some may come from the state Supreme Courts if there is a question of the Constitution. There are 94 federal district courts, and you also have tax courts dealing with the Internal Revenue Service, claims court for claims against the United States government, and of course you have the military courts. How do you get appointed to the federal courts? You're nominated by the president, confirmed by the Senate. If it's a appointment to the Supreme Court, the majority party in the Senate is going to control. If they are appointments to district courts in the states, the senior senator of the state in which the judge would serve has what's called senatorial courtesy. If that senator disagrees with the president's appointment, the rest of the Senate, by courtesy, will not approve of that appointment. The courts reflect changing demographics. Slides I have, the next couple of ones, as recently as the Clinton administration. The point being in all these slides, regardless of the president's party, more and more females and minority judicial employees are coming to the court system. You have more African Americans, you have more blacks that are being appointed to the court systems. And you have more Hispanics. It's looking at the most recent appointment with Judge Sotomayor to the Supreme Court.